What's up, everybody? Welcome back into the episode of The Lawyer You Know. And I get so many questions on all these Brian Walsh, Miles King hearings. I didn't do a video on the last one. Everybody's like, oh, we need your thoughts. Not much happens, but the judge did say in this hearing today that there was incremental progress. We'll talk about what that is, why this case is so unusual, what we hope actually happens, and what the major problem is with what the prosecutor says. Because while there is incremental change, it highlights a much bigger issue that is overarching in everything that's going on in all of these cases. And after that, we're going to listen to that entire hearing. It's only 15, 20 minutes long. Then we are going to read the factual basis for the civil complaint against Karen Reed. What do the O'Keefes allege? Karen Reed and the alcohol establishments. And we'll talk a little bit about the dram shop law in Massachusetts, but we're going to be digging into this complaint more over the coming weeks and months as the civil case ramps up, because I assume it's going to move faster and more furiously because Alan Jackson and some real aggressive litigators are coming on board. So make sure you guys hit that like button. Make sure you're all subscribed to our page. Let's get to it. All right, let's jump in to this Brian Walsh hearing, figure out what we can learn and what this incremental progress is that the judge said happened today.
On the Zoom is Mr. Tipton. Mr. Tipton, could you identify yourself for the record?
Yes, Larry Tipton for Mr. Walsh. Attorney Porges will not attend today.
And Mr. Walsh is here. Mr. Walsh, can you hear us? You can just wave or whatever.
I can hear you. Thank you.
Thank you.
All right. Mr. Tipton, we still have to fix your microphone. Still tough to hear you, sir. All right. Where do things stand, Attorney Beatty?
Your Honor, I've had the opportunity to have further conversations with the U.S. Attorney's Office, and I can report the following to the court. Ordinarily, the U.S. Attorney's Office would have 2 weeks to reply to the motion that the Commonwealth filed in federal court. We've had some productive conversations, and we're hopeful that we've reached an agreement that will narrow the issues for some period of time.
So this is the prosecutor saying, we've been in contact with the feds. We've been able to have more conversations and more productive conversations to where we think we're going to be able to whittle down some of these issues. And there's more coming, but this is kind of the beginning of finally some headway. Finally, we may actually be moving the ball down the field, as opposed to every single time us being like, sorry, nothing we can do. We think that'll violate the protective order. Judge, are you telling us to violate a federal protective order? I didn't think so. What are we supposed to do? Our hands are tied with the feds. Well, what about the justice for the victims? What about a fair trial for the criminal defendants? What about justice?
They will be filing a response to our motion in court, seeking modification of the federal protective order, which will do a number of different things. The first thing.
So the feds are now considering modifying their protective order. And we know that will be incredibly important when it comes to what everybody can look at, what the judge can consider, and what eventually may be turned over to all these different defense attorneys that want it, especially with regards to the Proctor communication. Everybody wants those texts, but there's so much more that could be available. We don't necessarily know, again, protective order, and they're going to use some very important words that let you know secrecy. We're not going to see this. We're not going to hear about this, but will it eventually get discovered by all these different defendants that are interested?
They will be seeking a modification that will permit the release of the previous court orders so that this court can review those orders. The second thing
So just the prior court orders, they're going to allow this court to look at. Isn't that nice?
The motion for modification will seek is permission for the Norfolk District Attorney's Office to review the remaining confidential materials that were provided to the Reed and the Reed prosecution and defense teams. So I want to be clear at this point, for the purposes of the record, that at this point in time, all of the Proctor chats or communications have been produced to the Norfolk District Attorney's Office outside of the protective order, and the Norfolk District Attorney's Office has provided those to all of the defendants who are part of this motion, and will continue to provide those to other defendants. However,
It's exactly what we thought would happen when we heard about the federal investigation, the Proctor texts, Proctor getting terminated, Proctor getting thrown under the bus. We knew. And usually this is taken negatively. I don't mean it negatively when I said all the defendants are going to come out of the woodwork and want this information. We're going to talk about Karen Reed's civil lawsuit and what the O'Keefes are alleging, what the facts are. One of the things that's really important in the civil lawsuit versus the criminal case is they don't have to eat Proctor and the bad law enforcement, the bad investigation. They don't have to eat it quite as much because it's not part of their team. Yes, it's going to affect their case. Yes, it's going to make their case a lot more difficult. But the Commonwealth was tied in with Proctor. They're on the same team. A vote for the Commonwealth is a vote for Proctor, just like I said, the whole time through the first 2 criminal cases. So to me, that's a really important distinction, and it's being highlighted here by all these different criminal defendants and criminal defense lawyers wanting this information. That should tell you just how unusual this is and how damning this is if they get their hands on it and if they're able to use it in their case.
for that left the remainder of the confidential materials, which we had not been allowed to review. So the motion will seek permission for us to be allowed to review those additional materials. I would characterize those.
That's the motion that you filed before.
We filed a motion for that, seeking that among other things. The U.S. Attorney's Office will file their own motion.
And they'll file a motion in accord with yours?
No, because there are what I would characterize as 2 groups of remaining materials. There are grand jury materials and there are non-grand jury materials.
There are grand jury materials and there are non-grand jury materials. What grand jury? We don't know, right? So there's a lot more here than just Proctor's texts. And there's a lot more that may be revealed throughout this process, because once attorneys, like sharks, a lot of people call us sharks, when you smell blood in the water, you get hungry and you dig deep, especially when they won't give it to you and they're blocking and something seems off. You push harder, you push harder. The more resistance you get, the harder you push. And so that is what I assume is going to happen here, that maybe it's going to be even more discovery than they bargained for, than they even thought was going to be available.
Their motion will allow us to review both sets of materials. We will be permitted to produce Rule 14 materials from the set of records that I would characterize as non-grand jury materials. We will not need to seek further court order or permission from the U.S. Attorney's Office if we review the non-grand jury materials and find Rule 14 material that is relevant to the other matters. We're calling them the other matters, these cases here that we're discussing. We do not have an agreement with regard to the grand jury matters. So if we review the grand jury matters and we find what we determine to be Rule 14 material, at that point in time, we would have to seek either a TUI or go back to federal court and file an additional motion before Judge Casper. The third thing.
So if after all this, when they look through stuff, they find things that are discoverable, they find things that are exculpatory, then they need to do another TUI letter. They need to get more information. They need to get it from the feds before they can turn it over. This is when he says incremental progress, when the judge says incremental progress, boy, should the emphasis be on incremental, right? The emphasis should be on incremental. You put the wrong emphasis on the wrong syllable. You guys remember that one? Because we are barely scratching the surface. It is important, and it seems like the prosecutor is pushing a little more to try and get the feds involved, try to explain to the feds how important this is, why we need this information, how important it is for us to do this. And my overarching thought and feeling about that and frustration is, why just now? Why years into these cases on some of the things, right? Why has it been years since we've known about the federal investigation in Karen Reed? It feels like we've known about this stuff for a while. Why did they not care to gather the information that may be discoverable, that may be exculpatory?
This is my understanding that the third thing that the U.S. Attorney's Office motion or response, however you want to look at it, will seek is a status on this matter before Judge Casper in 45 days. So if Judge Casper agrees with that, we will not have a return or destroy deadline that is pushing the matters at this point in time.
Meaning if they can push the destruction of these potentially very important documents and things off, it gives us a little more time to deal with it. To me, duh, like obvious. Why would the feds not do that? In the interest of justice, like why would they not? Seems simple if you can just get somebody's attention, right?
And does the U.S. Attorney's Office also agree to the tolling during the period between now and whenever Judge Casper decides?
Yes, they had already
agreed to that.
Let
me just see if I can recap.
Thank you.
As best as I understand it. There are two types of materials that have not yet been produced to the defendants in this case.
That have not been reviewed by the Norfolk Attorney's Office and have not been produced for these cases.
All right, so let me just go slow here.
Right.
Certain documents have already been turned over to these defendants under protective order,
Yes.
which came from the U.S. Attorney's Office.
Yes.
Okay, but leaving those aside, of the materials that are part of the confidential material from the federal court, there are two categories. One is grand jury materials and the other is non-grand jury materials.
Yes.
You haven't yet defined what you mean by grand jury materials. Presumably, if the grand jury took testimony, that would include transcripts of testimony. I don't know if the grand jury issued subpoenas. I don't know, and I don't know if you're considering subpoenaed material to the grand jury to be grand jury materials. But let's leave that distinction aside. Whatever constitutes grand jury materials, there's some other stuff that is non-grand jury materials that was collected by the U.S. Attorney's Office in connection with this investigation related to the Reed case. And what you have is an agreement from the U.S. Attorney's Office that as to the non-grand jury materials collected by the U.S. Attorney's Office and produced as confidential material in connection with the Reed case, the non-grand jury materials, even the U.S. Attorney's Office would agree to allow you to review and to determine whether anything in that material should be produced in King or Johnson or De Los Santos or any other of the cases that involve Trooper Proctor's investigation. As to the grand jury materials, they still are opposing your ability to produce any of that material and opposing your ability to review any of that material. Is that correct?
No.
No.
We are allowed to review those materials in order to determine whether, in our opinion, there is Rule 14 material.
Okay.
So that whole thing about, oh, we're scared. We don't think we can review it. We think that would violate the protective order. It's like, nobody really understood that. It's like, review it to see if you're even going to turn it over. Is that really violating the protective order? They kind of hid behind that as the prosecutors. And guess what? Shocker. When they asked the feds were like, no, you can review it, but don't turn it over. It's like, and then if you think you need to discover it and you need to turn it over, then you ask us, then we'll talk about whether you can turn it over and who can look at it and whether it's going to be public or just the lawyers can look at it or the clients or the judge. We are so many steps away, but at least it seems like it's going to happen, even if it's eventual. Sleuthy said, I think the feds are hesitant to turn a lot over to the Norfolk DA because much of it is about the same DA. I mean, yeah, but why would you need to destroy all this stuff, right? And if you're going to turn it over to both sides. Turn it over to the judge. They have a lot of control over how they handle this situation. Jillian May said, at this point, I'm pretty over Karen Reed. I was super invested in the trial, but I don't care anymore. We've been talking about it for years. And I just highlighted this comment because, yes, I know that there are people that feel that way, and I understand. And we're not just covering Karen Reed. Obviously, we're covering Adelson. We're covering, this Walsh and Miles King, adjacent to Karen Reed things, and other trials that are still going to come and people are asking about. But as always, whenever people are DMing me about on Twitter and Instagram and asking me about and sending me links and documents on, usually that's what I'm going to cover. And these are some of the most requested things out there. So that's why we're covering it. The DA office will reveal if there is Brady evidence, but in the Reed case, they said no Brady in here, yet there was so much there. It is concerning to me, should be third party, in my opinion, to review. And I think the defense is going to push for as much of that. They're probably going to want some kind of log like, okay, this is grand jury material. This is Proctor material. What exactly is it? There are ways to try to dig in, but you can see, we see it in a lot of cases. In Koberger, we saw it. So many different cases we saw where they're like, we know something like that has to be there and we're not seeing it, judge. So we're going to call BS on this. And there are legal ways to push that. And it's not The legal terminology is not calling BS. Hey, Peter, between this and Turtle Boy's case, something's always missing and judges keep pushing it to the next court date. Annoying sidebar. Love your vibrant shirt. Just blends in with your complexion and vibe. Thank you so much, M. Medina. Here's what I'll say. This case is what's happening here with Miles King, Walsh, etc., is a great example of how the Karen Reed case and all of these cases, it's just very abnormal, one of one, so many different things. Okay. And from my perspective, when we have a situation where it's an interesting one-off, it's cool to cover it. But how slow cases move is not abnormal. So many cases, these cases just get kicked to the next hearing, kicked to the next hearing, kicked to the next hearing, pass the buck. Somebody else needs to handle this. And that's just how it happens sometimes. And that's our legal system. That's our justice system. It's not great. It's not perfect, but we try to move these things forward. And we're going to continue to see just how much power prosecutors and law enforcement have, which is why it's so important to hold them accountable to do their job. They're the first line of defense in all of the criminal justice system. They need to do their jobs right, and everybody is more protected.
So at this point, they're taking the position that the non-grand jury material may be reviewed by you and turned over without further order, although I guess it's subject to their production of the documents to you other than through the, under the protective order.
I think that we don't have this finalized yet, but my impression was that we would be able to use the documents that we already hold.
Okay. And are they taking the position, the U.S. Attorney's Office taking the position that notwithstanding the protective order issued by Judge Casper, they can make that determination unilaterally?
No.
So they're seeking a modification of the protective order to allow them to give you the authorization to review it separately?
Yes, so this
Okay.
is all subject to Judge Casper's approval.
All right. And then with respect to the grand jury material, however that category of universe is defined, the U.S. Attorney's Office is taking the position, at least as in front of Judge Casper, that you can review it, and all the other prosecutors involved in this case, the other cases, the related cases, can review it to make a determination as to whether it contains anything that needs to be produced as exculpatory evidence or impeachment evidence under Rule 14. And
I know that it will be all the prosecutors in the office. I think there will be at least 2 prosecutors in the office, 2 prosecutors probably who have already signed the acknowledgement, who will be able to do the review.
okay. The U.S. Attorney's Office is asking for a
This is just them basically going through the procedure of how this is going to work, who's going to look at it. They're going to sign the acknowledgement, meaning they're under the protective order. They can't tell anybody what they're looking at. They're going to figure out if it's exculpatory, if it's Rule 14, if they need to discover, if the judge needs to look at it. They're going to go through that analysis. So that's the incremental progress we're talking about here.
status conference in 45 days. Presumably, Judge Casper might decide it much sooner than that.
I think what they are hoping is that they will file the motion, Judge Casper will act upon the pleadings, and then the 45 days would be scheduled from whenever it is that she issues her order, assuming that she adopts this proposal.
What's the 45 days for?
For a status to see where we are. I don't know how long this process is going to take.
You can always hide behind that. Whenever there's an unknown, it's like, Judge, this could take a really long time. I don't know how long this process could take.
Oh, you mean a status on the return of documents after this review has taken place?
It's like, oh, you mean the step before the step. It's like, so we're trying to get here, but we've got to take this step. Oh, but we got to do the step before the step, Judge, and then this step, and then it's like there's so many steps to get to where we want to go. So don't get your hopes up. This is not going to move quickly. There's going to be another hearing. It's not going to be over then. Who knows if and when Lally and Proctor are ever going to testify. I don't care how many times they try to tell us, oh, Lally and Proctor are going to testify today. I'll believe it when I see it. I think this is going to be long and drawn out. So I understand the people that are bored of it, and I understand the people that have questions about it. If you have questions about it, that's what I'm here for. Also, Louise said, I'm not tired of this case as long as there's corruption in this county commonwealth. We're not done yet. Well, the we're not done yet part with reference to Karen Reed's attorneys, I really think 1983 might be coming sooner rather than later. And that I think is going to be pretty explosive. And that is going to be something I think we're going to want to follow, as well as the civil case. The lawsuit against Karen Read is really interesting to me because it is a different burden. It's a different theory. It's pretty purely negligence for most of the counts. But we're going to be digging into that civil lawsuit more and kind of explaining the differences between the civil process and criminal process and why it's not a guaranteed win for her in the civil process just because she won in the criminal process. So that's going to be really interesting as well. I don't think we've ever covered like a pure car accident type of case here, even though, of course, most people believe there was no car accident.
Right. I don't know if we'll be able to do the review in 45 days. I'm optimistic, but anything can happen. And so I think the suggestion was this way we don't have this deadline that is just pushing everyone. And so then we can see if we've been able to complete the review, if we can continue to discuss the issues that remain, or if there needs to be further litigation or what needs to happen.
Okay, so we are making progress, incremental progress.
It's like it's progress, even though it's small. It's incremental progress.
Or from anybody else between the last hearing and this hearing. So all of this is being reported to me for the first time orally here in court. Maybe it's true also for defense counsel hearing it for the first time here in court. Does defense counsel have any thoughts, concerns, issues?
Yeah, Your Honor.
I'm sure you have thoughts and concerns and issues, but my gut feeling here is we're going to need another hearing on this, and I'm not sure that less than a week, or a week's time, anything longer than a week might not be appropriate because we don't know what Judge Casper is going to do. We don't know if she's going to adopt the tolling. We don't know whether.
That's exactly
what Judge
Casper says.
Right. It seems to me unlikely that she would say no, but I don't know, and I can't assume the conclusion here. So,
Is there, can I ask a question, Judge?
sure.
Is there any agreement between the Commonwealth and the U.S. Attorney's Office not to destroy the documents until Judge Casper makes a decision? And can we have a day after that decision to get in here and talk to you?
What do you think?
Well, I've always said that we would not return or destroy before Judge Casper made a decision, and that the U.S. Attorney's Office has agreed to that. I do want to say that I'm out of state next week, so I would
We've always said we'd do that, Judge. Like, forgive us for maybe not believing you.
be asking to go to the following week. If something comes up, I can get on Zoom if necessary, but. So the only concern I have, and I'm never going to interfere with anyone's vacation. The only concern I have is if Judge Casper makes a decision tomorrow or Monday that says this order isn't getting extended for whatever reason, we're out of Judge. That's my concern. If this order expires, the order that we have right now, I know there's an agreement between the Commonwealth and the U.S. Attorney's Office, but it's not their order, it's the judge's order. So if the judge says no on Friday or Monday, then what happens?
It's like, what if something happens while you're out?
What do you think?
I will notify the court and I will get on Zoom if that happens.
Okay.
That's just on behalf of Mr. De Los Santos. Again, in theory, this does sound like progress. I do share the concern if a decision comes out from the federal court from Judge Casper. I'm comfortable enough with a 2-week date with the caveat that if circumstances on the ground change and the landscape in federal court changes, that we could have this case advanced to address the court.
That's where I was coming down, okay, is put this on for a next hearing, August 27, 28, 29, something like that, convenient to the parties, dog days of August, with the additional order that upon a decision by Judge Casper, all parties, all defense counsel, and the court will be notified within 24 hours so that we can accelerate proceedings on this case, if need be, before the 27, 28, 29.
Because I'm not available on the 27th because I have an all-day motion to do trial here in Suffolk. Do what I have on the 28th, make myself available if that works for the court and the parties.
The 28th or the 29th is better.
I'm here on the 28th.
Okay, so the 28th at what time?
At 2?
Yeah, let's do 2 o'clock.
Sure,
This is just scheduling 28th at 2. I think this is the end of it, basically.
that's king here.
The 8th of August.
I'm fine, Judge. I'll appear. If I can, I'll appear by Zoom. If I can be present, I'll be present, but I'm there.
Okay. Anything else we should take up?
And I feel confident now that the information isn't going to be destroyed by Monday. And if it is, we'll have the opportunity to speak to you before that happens.
Defense is like, at least we know it's not going to get destroyed. And if it is, we'll know about it first.
Okay. Mr. Tipton?
Yes.
The only thing I want to say, and I'm not going to belabor it, we'll address it on the next one, but we have in my case, we have a trial date coming up in October. If we're talking about 45-day status date, then we're talking about the grand jury, then we're talking about TUI. I'm just putting a bug in everybody's ear that we do have an October trial date, and everything needs to be done expeditiously in the Walsh case at a minimum. I'll leave it at
The
that.
Commonwealth is mindful of the Walsh trial date and has expressed to the U.S. Attorney's Office that we are anxious to bring that case to trial and do not want there to be any delay, and we will be acting accordingly.
Yeah, he's like, we need this date. By the way, will it get continued? Probably because all this. But while you have the date, you can get a lot of things done up to that date, including push the feds. So they'll probably use that to continue to push. But if it's really moving this slow, I expect them to have to continue that. But it's pretty brutal. But from my perspective, you have to use the trial date while you have it. And of course, everybody's going to say they want to get the trial, especially the Commonwealth. They're like, we're very anxious to try that case.
Judge, the only other concern I have is the 2 attorneys that are going to be authorized. I would assume that they would have conversations with the attorneys that are assigned to the case so that they know what.
I'm not going to micromanage the district attorney's office's obligation to produce all exculpatory evidence. They will have to bring somebody up to speed so that if they are limited in who can review the capital C, capital M confidential materials as defined in the various orders, that those people are in fact up to speed.
Thank you.
Okay.
Thank you, Your Honor. Thank you, Mr.
Thank
Clerk.
you.
Thank you, sir.
Sure.
All right. That's it for that. And now we're going to get to the civil lawsuit here. Let me answer a couple questions first. Margaret said, I'm still into all things Karen Reed related. If you are still interested in Karen Reed stuff like this civil lawsuit, hit that like button, please, if you guys have not already. Priya said, if delayed, will Walsh get out? Highly, 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 highly doubtful. Because of his past, because of his prior issues, because of the evidence they have against him, the likelihood of guilt, as they say, when they consider, bond and things like that. Highly, highly, highly doubtful. Jen said, I've been rewatching the old Lawyer You Know videos to catch up on the Adelson case. I encourage everybody to do that. If you're going to watch the Donna Adelson trial, go watch the old Adelson videos so you can start to try to figure out what a web they weaved as an entire family and how we kind of got here, because it's incredibly wild. And it's so fun to see how much you and the channel have grown. Thank you so much, Jen. Chris, for the civil case, why is it called Dram Shop? Is it an abbreviation? Insert sarcastic comment about you just being a civil lawyer here. I don't think it's an abbreviation. I don't actually know the answer to this. My guess would be, like, I think dram has something to do with like liquid or like a unit of alcohol or liquid or something like that. There's something in my brain that's telling me that. That could be completely wrong. I really don't think it's an abbreviation, but I could be wrong. I don't know where that came from, historically speaking. All right, let's get to this civil case for just this civil lawyer here. Here we go. All right. So what we're going to do today is we're going to take an initial look. We are going to dive into the facts. We're going to talk about how they may or may not be able to prove these facts. We're going to look at some of the causes of action. I think I'm actually going to look at some of the dram shop and causes of action against other parties, because on Monday, I'm going to do a podcast where I dig into this even more. And we really dig into what's the difference here between this and the criminal case. What are some of the questions you guys have? Let me know on Twitter, on Instagram, because I really want to dig in and answer the questions you have about this civil case. What does it turn on? How do you prove things like this? Do they have to use the Commonwealth's experts? Are they going to hire their own experts? What kind of experts do you think they're going to hire? I have friends following this stuff that have been texting me like, what do you think they're going to do? Like, who's ARCA's counterpart? Who do you put up against Arca? I said there's about 1 billion people you could call, all probably better than the Commonwealth's experts that do this stuff. Now, will they be able to find something? Will they be able to use something to explain this? I don't know, but I would be shocked if the plaintiff's attorneys use Welcher or anybody associated with Aperture on this civil litigation as plaintiff's lawyers. I expect them to pick somebody different, but who knows? All right, we're going to skip the parties and jurisdiction where they go through who everybody is, and we are going to read the facts. The facts, because when we read the motion to dismiss, when we're discussing some stuff online, everybody's wondering, what are they claiming? What can they prove? How can they claim something that's different than in the criminal case? Let's take a look here. Plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety all prior paragraphs of the complaint. The decedent, JJ, was the middle of 3 children in a tight-knit family. JJ was a third-generation Boston police officer. After the tragic death of JJ's sister, Kristen, and brother-in-law, Steve, JJ took custody/guardianship of his niece, Kaylee, and nephew, Patrick, who were 6 and 3, respectively. Over the next 8 years, until his tragic passing, JJ raised and supported his niece and nephew. You need to discuss and create the relationships here, who everybody was to each other in order to support the damages and the factual allegations you have in some of these counts. That's why there's this background. After the tragic death of JJ, Margaret took guardianship, custody of her grandchildren, Kaylee and Patrick. At all relevant times on or before January 29th of 22, JJ and defendant Reed were in a dating relationship. In the months, weeks, and days leading up to January 29th, JJ and the defendant Reed's relationship was deteriorating. During such time, defendant Reed picked fights, experienced jealousy, and had delusions of unfaithfulness. So here's something right here, okay? These types of allegations and these types of lines, like talking about them fighting, this is where you start to wonder, are they going to say she did this intentionally? Are they going to say she meant to do this? Because when you have civil cases, which there was some discussion online and there will be a lot more next week, if it's an intentional tort, most car insurance companies will not cover that. We're going to talk about DUI, drunk driving, and things like that as well. So you have to be very careful about what you allege in a complaint, because usually you want to hook the insurance. I don't know what her policy limits are, but if they're going to get a settlement, it's much easier to get it with an insurance company than somebody individually, no matter how much money they have. On or about January 28th, the defendant knew that their relationship with JJ had run its course. Why is that important if we're talking about a car accident, wrongful death, right? On January 28th at about 8:51, plaintiff arrived at CF McCarthy's, kissing and hugging and drinking and hanging out with her, knowing the relationship had run its course. That doesn't vibe. And we know that doesn't jive. It doesn't jive. And we know that that's going to be a lot of the push for the defendants, that that's not actually true. They don't need that, in my opinion, to prove most of their cause of action. As a civil lawyer, as a plaintiff's lawyer, if I'm trying to prove this, I don't want to make my job harder with bad facts like that. CF McCarthy's was licensed to distribute, sell, or serve alcohol. Why is this an important fact? Why did they put that in there? For dram shop cases, this is an important element that you have to prove. If I give you a beer at my house, now there's still some things you can sue me under, but it's not dram shop, right? You have to be licensed to distribute, sell, or serve alcohol. On January 28th, at or about 8:58 p.m., CF McCarthy served Reed an alcoholic beverage. Reed consumed said drink. On January 28th, CF McCarthy, through its agents, servants, or employees, served alcoholic beverages to defendant Reed on or about 9:13, 9:20, 9:33, 9:57, 10:22, 10:29. Reed consumed such drinks. So 1, 2, 3, 4, 5, 6, 7. Now, here's where it gets kind of important with, did she finish them? Was it water? Did she walk out? Did John drink any of them? In the other case, it was kind of like, was she drunk driving? Probably the jury said she was. And, she kind of admitted it in some of the interviews, and they were willing to lose that. In the dram shop case, though, if they were serving multiple people, if she wasn't drinking them, if they didn't see her drink them, from their point of view, from the actual establishment, that could absolutely make a difference. And we'll see how those facts develop. And that's going to be kind of a different angle than we saw in the criminal case, which is why this civil case is going to be different. There are going to be major differences. And this is one of them. Now, comparing Massachusetts dram shop, which I figured out just by reading this complaint and doing a little research, because I was like, not so sure this would fly in Florida. Florida has a much more restrictive dram shop law. I've litigated dram shop cases. We have a lot of dram shop cases even in our office right now. Most of the time, you have to serve underage people, or knowing people are habitually drunk and coming in your establishment. There's a lot more notice in Florida. It's not just necessarily over serving somebody or serving somebody at all. In Massachusetts, it's a little easier. Over serving somebody, continuously serving somebody that you should know is intoxicated or that looks intoxicated could be enough. But again, we know some facts are going to come out. Karen Reed seemed perfectly fine. Kokinas, right? Nice Greek lady. Was talking to her all night at the end of the night. She seemed perfectly fine. And take Karen Reed out of it for a second. Just these establishments. They're going to use those witnesses. They're going to highlight those witnesses. And you have to be careful when you sue multiple defendants. They hire multiple defense attorney firms, more resources, more people agreeing, more witnesses being questioned by more lawyers for the jury to hear. Wait, instead of it just being the prosecutor and the defense, and usually they believe the prosecutor, now it's the plaintiff's attorney and these defense attorneys. It's like these three lawyers seem to be on the same page and agree against just that one little bitty lawyer over there. And you could have multiple ones at the table, but you can see how it starts to build something very different looking at the jury. And I'll say a lot of juries look at plaintiffs and they're like, why do you want this money? Are you filing this frivolous suit? Are you just looking for a money grab? The money's not going to bring him back. Sometimes civil plaintiffs can be more similar to criminal defendants than you would think. Okay, let's keep reading here. So CF McCarthy's, through its agents, servants, or employees, served defendant Reed 7 alcoholic drinks between 8:58 and 10:29. Now, 7 is a lot. I haven't looked through the entire jurisprudence on dram shop law in Massachusetts. Maybe there is a number where it's like you should never serve anybody more than 7 drinks. I would think not, or all bars and clubs should know that. During all relevant times before 10:29 on January 28th, defendant Reed showed signs of intoxication while at CF McCarthy's. And that's important. Did they know she was drunk? Was she habitually in there drinking? Did they overserve somebody they knew was intoxicated? On January 28th, on or about 10:40 p.m., JJ and the defendant Reed left CF McCarthy's. On January 28th, at or about 10:40, defendant Reed was allowed to carry her alcoholic drink out of CF McCarthy's. Now, how much are they going to be on the hook for that? How's a jury going to look at that and say, oh, they should have stopped her, they didn't know, etc. On January 28th, at or about 10:54, JJ and defendant entered the waterfall. Okay, enter the next defendant here. At all times relevant, Waterfall was licensed to distribute, sell, and serve alcohol. The defendant Reed walked into the Waterfall carrying a drink from CF McCarthy's. At all relevant times on January 29th, while at the Waterfall, Reed showed signs of intoxication. How are they going to prove that? I don't remember anybody really testifying to that. Even the Alberts, McCabe's, O'Keefe's. I mean, O'Keefe's weren't there, I guess, but nobody that talked to her really said, oh, she was sloshed and slurring her speech and obviously intoxicated. So if nobody could tell she was intoxicated and she walks into the Waterfall, how's the Waterfall supposed to know? They don't know what she did at CF McCarthy's. So I actually think the argument's better against CF McCarthy's than it is the Waterfall. Between 10:54 and 11:54, the defendant Waterfall served Reed 1 shot and 1 mixed alcoholic drink. Reed consumed such drinks. So think about that. Talk about a weak claim, in my opinion, unless she was obviously intoxicated, walking in, stumbling, and you should have known. But if she wasn't, which it seems like all the evidence we know of says that she was not, 1 shot and 1 mixed drink, and you're going to file a dram shop case against them? To me, that's incredibly weak. Incredibly weak to the Waterfall. 7 drinks in a couple hours. Okay, maybe you got something there. At all relevant times on January 29th, between 12:11 and 12:36, the defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. At all relevant times on January 29th, the defendant Reed drove JJ to the residence of 34 Fairview. Defendant Reed and JJ had been in an argument the night of January 28th into the early morning of 29th. Why add this stuff in there? After JJ got out of defendant Reed's vehicle in front of 34 Fairview on January 29th, Reed drove her SUV and hit JJ. Intentional, reckless, negligent, accidental. Just says she drove her SUV and hit him. At all relevant times on January 29th, defendant Reed drove her SUV in a state of intoxication. As a result of Reed's SUV hitting JJ on January 29th, JJ was knocked down onto the ground in front of 34 Fairview, suffered serious injuries, and died. After hitting JJ with her SUV, the defendant Reed fled the scene and returned to JJ's residence at 1 Meadows Ave. At all relevant times, the defendant Reed knew that it was snowing, knew there was an impending blizzard, and knew or should have known that leaving JJ outside in the blizzard would likely result in serious injury or death. At all relevant times when defendant Reed drove her SUV and hit JJ, the defendant Reed, here we go. Here are some important civil parts. Failed to use any care to avoid creating an unreasonable risk of harm to the public and JJ. That's negligence. That's recklessness. That's not intentional. She voluntarily took an obvious risk under the circumstances, knew or should have known that death or serious injury was reasonably predictable. Persisted in a clearly negligent course of conduct over a noticeable period of time. So that's where we see some negligence. They're throwing negligence in there now. Was impatient with reasonable precautions. That strikes me as negligent. Was deliberately inattentive to the predictable hazards of her actions. Deliberately can make you think intentional. Inattentive, deliberately inattentive is kind of reckless. This is not the common normal language. You want to make it simpler, in my opinion, as a plaintiff's lawyer. Was deliberately inattentive when there was a risk of great and immediate danger. Recklessness generally. At all, and with intentional torts and recklessness and with DUI, you can get what we know as punitive damages, which is additional damages to punish the defendant like Karen Reed for this wrongdoing if, in fact, they prove this in a civil court. But punitive damages are not covered by insurance mostly. You can probably get insurance for it, but at all relevant times when defendant Reed drove her SUV and hit JJ, defendant Reed was reckless when she intended the reckless conduct that resulted in JJ's injuries and death. Okay, clear recklessness here, they're alleging. Her conduct made it highly likely that someone, namely JJ, would suffer serious injuries or die. She knew or had reason to know of the risk of grave injury or death to JJ, or said risk would have been obvious to a reasonable person, and she intentionally or unreasonably disregarded that risk. JJ's injuries or death resulted from defendant Reed's decision to engage in the conduct referenced above in 16, 17, 26, 37. On January 29th, approximately 4:30 a.m., defendant Reed knew that she hit JJ with her SUV. Nevertheless, she woke up JJ's 14-year-old niece, Kaylee, and talked about JJ's death, talked about hitting JJ with her SUV, and otherwise involved Kaylee in her frantic calls about JJ's death. And this is where we get into the negligent infliction of emotional distress and intentional infliction of emotional distress, which we broke down at length a couple days ago. I think it was a couple days ago. I don't even remember. At all relevant times, on or about January 29th, defendant Reed knew that Kaylee was a vulnerable minor who already lost her parents tragically and depended on her custodial uncle JJ, who became her surrogate parent. We talked about how that's an important element. At about 5:07, defendant Reed left 1 Meadows Ave. She knew he was seriously injured. Okay, the knowledge. What did she know? She knew she hit him, then she left him. That's what they're alleging. That's what they're going to have to prove. That she knew. Because she doesn't need to know for a wrongful death claim. For a negligence claim here, to prove that she hit him and left him and he died, you don't need to prove knowledge. This makes it harder. And we know it's going to be very, very, very difficult for them to prove knowledge. She went to where she left him to die. She repeatedly admitted that she hit him. We know how that's going to go. She arrived at 34 Fairview, immediately observed him laying on the ground, buried in the snow where she had left him earlier to die. JJ suffered traumatic injuries before becoming hypothermic. JJ was pronounced dead at the hospital. She went to the grieving house, feigned comfort, used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and or destroy relevant evidence. Are they talking about the Ring camera? We don't know. How are they going to prove that? Reed's blood was drawn. She had a BAC over 0.08. Reed's BAC of 0.13 to 0.29% all exceeds the legal limit to drive. As a direct or proximate cause of Reed's drunk driving, JJ sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings. Those are the damages. Notwithstanding her Fifth Amendment right not to speak, Reed chose to speak publicly, knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. Okay. The false narrative, creating a false memory, some would say, like Officer Dever. She publicly communicated this false narrative, thereby frustrating justice for JJ. Such false narrative caused the plaintiffs aggravated emotional distress. The plaintiffs listed above bring this complaint seeking full and complete justice for JJ. So those are the factual allegations. Let me hit some of the questions here. Tracy G. Dram shop goes back to when alcohol was dispensed by a pharmacist. A dram is a unit of measure in pharmaceuticals. Okay, that makes sense. That's like why probably it was in my brain somewhere, but I could not have explained it as eloquently, Tracy, so thank you. Sleuthy, can witnesses' prior testimony in the criminal trial be used in the civil trial? Absolutely. A sworn under oath statement can always be used to impeach somebody. And all the witnesses should go back and study what they said to make sure they're not being inconsistent, make sure they're telling the truth. And if they are changing, then it absolutely can be used against them to impeach them. Absolutely. Peter, would you take this case for the O'Keefes? So knowing what I know now, this would not be a case I would take. I would not feel confident that I could prove that Karen Reed hit John O'Keefe with her car, which is what you need to prove these cases. So obviously the wrongful death claim, which we'll look at. So the wrongful death claim against Karen Reed. Actually, let's just focus on the dram shop case here. So let's take a look at these real quick. C.F. McCarthy negligently served alcohol to an intoxicated person, Reed, knew or should have known that defendant Reed was intoxicated. They violated Massachusetts dram shop laws, company safety policies, and otherwise negligent for numerous reasons, including but not limited to its decision to not hire competent employees, staff, bartender, server, its decision not to provide adequate personnel to work at C.F. McCarthy's at relevant times, its decision to not provide adequate safety training to its employees, staff, bartender, servers, its decision to violate its safety training, its choice to retain unfit employee, staff, bartender, servers, its choice not to supervise adequately its employees. The defendant, C.F. McCarthy, acted not only with indifference to its legal duty not to serve intoxicated persons, but also with utter forgetfulness of said duty. The defendant, C.F. McCarthy, acted with gross negligence. The defendant, C.F. McCarthy, acted with willful, wanton, and reckless disregard for the safety of others when it served an intoxicated defendant, Reed. The defendant, C.F. McCarthy, deliberately ignored appreciable risk and or voluntarily incurred the obvious risk of serving defendant Reed when she was already intoxicated. C.F. McCarthy's persisted in serving Reed alcohol well after it knew that defendant Reed was visibly intoxicated. By the way, these are going to be mirrored with the waterfall, so we're just going to read this one to get the point. McCarthy's continued to serve Reed alcohol at relevant times when Reed was already intoxicated. They have to know this. As a direct and proximate result of defendant McCarthy's negligence, gross negligence, and or willful wanton disregard for the safety of others, JJ, here's the important part, JJ, so because of their negligence, because of their serving a known intoxicated person and continuing to do so because they either didn't care or didn't have well-trained employees or didn't know what they should do, because they overserved an intoxicated person, JJ sustained serious injuries of body and mind. As a direct and proximate result of defendant C.F. McCarthy's negligence, JJ's next of kin suffered as well. So what does that mean? What it means is, in order for them to be successful in the dram shop cases against McCarthy's and the waterfall, they have to prove there was, in fact, a collision. Because if Karen Reed did not hit John O'Keefe, even if they're over-serving of an intoxicated person, if they prove that, it's wrong. They shouldn't do it. They violated a lot of these laws, but they did not cause the damage. They have to cause the damage, which is the damage done to John O'Keefe, in order for the plaintiffs to be successful in these claims. So all of these wrongful death counts against Waterfall, against C.F. McCarthy's, against Karen Reed, they all must include a collision. And we know that is going to be the difficult part. Now, the negligent infliction of emotional distress against McCarthy's and Waterfall, I think there's absolutely no shot. There's no way they should be able to go forward. if they want to say what Karen Reed said and did, et cetera, maybe they'll be able to get past a motion to dismiss there, which we went in detail before. But man, I just don't see how they get it against the Waterfall and CF McCarthy's. To me, this is just not what these laws are intended for. Matthew said causality is complicated in civil. I'm learning. Yeah, we call it causation for the most part. Yeah, you have to actually be the cause of the damage. You can do all these horrible things, but if you didn't cause the damage, you're not the right person to sue. And we have things called intervening superseding causes, where somebody, let's say somebody gets in a car accident, somebody's injured, and EMS shows up and they put them on a stretcher, and then EMS drops them on the stretcher and they break their neck. Who's at fault for the broken neck? Obviously the EMS, because they dropped them. But you can also sue the person that caused the car accident because they never would have been on the stretcher if they didn't get hit in the car accident. So there can be multiple causes for one injury, and it can get very complicated. But you have to be able to prove who caused what and how they caused it. And there has to be a cause of action for you to file under. You can't just say she was drunk, dram shop, obviously sue them. Different laws, different jurisdictions allow you to do different things. But it really is a situation that this is something the plaintiff lawyers are going to have to prove, and it's an uphill battle based on what we know from the criminal case. Now, they can have very different experts, which can produce very different evidence and testimony, but we'll see. Ashley, why wouldn't the O'Keefes try to go after the Alberts homeowners insurance? So a condition on the property of the Alberts would have had to at least partially cause or be at fault to be liable for John O'Keefe's injuries and death. So if they believe Karen Reed hit John O'Keefe, then what would be the condition on the property? I kind of think if I'm going to put my civil lawyer hat on, my plaintiff's lawyer's hat, and I want to be creative, and I want to try to get everybody that could potentially be liable for this, there's multiple angles that they could sue the Alberts. Number one, obviously, if he didn't get hit by the car and, there was a fight inside. If he slipped and fell inside at the gym and hit his head on a bench. If he slipped and fell in the garage and hit his head on the side. Any accidental fall inside the house, obviously, you could have a claim against their homeowner's insurance. But if they knew or should have known he was going to be outside, if they saw Karen Reed's house, did they have a duty to walk outside? If they walked right by him, right by his body, laying in a very small front yard and didn't see him, was that negligence on their part? Or any of the bystanders or people that were at the party? Was there negligence in failure to render aid? What is their duty? Some interesting ways and angles to potentially go after something like that. I think we all know the reason why they're not. They seem to be aligned in how they view what happened to John O'Keefe, and they seem to think that Karen Reed was at fault and the bars that served her, I guess. Can Karen Reed's insurance company settle without her okay? So technically, yes, they can. So here's what can happen in civil cases. We're pretty much done with the complaint here. But I'm going to be digging into this more on Monday. So if you guys enjoyed this talk, we're going to nerd out on the civil complaint and go through a ton of different things. And you're going to learn a lot about the civil case if you want to. So insurance company lawyers usually send a letter to the insured, Karen Reed in this case, saying, we represent you, but we really represent the interests of the insurance company. And we'll notify you about offers, even if you want to settle. If Karen Reed was like, they only want $25,000, please pay it so I can be done, and they say no, it's up to them. It's their money. And I've been personal counsel for people in Karen Reed's. I've never represented an insurance company, never will. But I have represented individuals that don't trust their insurance company or don't trust their insurance company lawyer, feel like they're trying to screw them, something like that. And if this happens, I will write a letter saying, it's your prerogative if you don't want to pay that $25,000. But if there's ever a point, let's say it's a $100,000 policy, where anybody comes after my client for more than $100,000, we expect you to pay it because you had the opportunity to settle within the insurance limits and you chose not to. And yes, it's your money, but your number one goal should be protect the interest of my client, your insured. So you can kind of put the pressure on them if you want them to settle. But you can't force them to because it's their money. And usually if they say, no, I'm not going to settle, they will eat any future excess judgment. Or there could be a bad faith claim. We're not going to dig into all that. But let's say the reverse, like you're asking. If they say, Karen, they'll settle for your 100,000. We don't want to have to pay lawyers $1 million to fight this case. We're going to settle for 100,000. She says, no, I absolutely don't want you to. Two things can happen. Number one, they can say, too bad, it's our money. We told you this in the beginning. We're going to do what we want with our money. We're paying them. Usually she's got to agree to a release or potentially sign a release. We'll see if that happens. Maybe not. Maybe they'll agree to settle without her signing anything. But another thing can happen. They can say, okay, Karen, if you're sure, but we're telling you right now, we are never paying $1 over 100,000. Or I think they'd have a hard time because usually they have a duty to defend. But if they say, we're not paying defense lawyers anymore, we're at our cap now, you can do whatever you want. You eat the liability. You no longer have the protection of the insurance company. And they can put the onus on you. So a bunch of different things can happen when offers start being made with insurance company money, and you as the insured might not always agree to it. Do you only take plaintiff's cases or do you defend? I kind of just answered this. 99% of the time, I only take plaintiff's cases. Once in a while, and it's an hourly basis, which I hate hourly cases. I take very few of them. I prefer to work on contingency. I prefer to be project-based, align with the client so they don't think I'm dragging my feet or making it take longer, billing unnecessarily. I just hate dealing with all of that. And I explain it to them, it's going to be more expensive than you want it to. So just get ready, try to give them a range, but tell them it's impossible to know. I do take some only representing people individually, not representing the insurance company. Am I correct that the Commonwealth basically gets to decide what's the exculpatory? And if they say there's nothing here, then the defense doesn't get the documents. Doesn't seem fair to me. So theoretically, yes, not just what's exculpatory, but what's relevant to their individual case. But that includes any impeachment information. And you better be sure, because if the Commonwealth really wants to do that and it finds out that they're wrong, there could be serious sanctions. There should be serious sanctions. Could it be mitigating defense that John O'Keefe voluntarily participated in the bar activities with Karen Reed, entered her car, and left her car at the bar? So usually no. Sometimes, I'll just tell you, some of the biggest dram shop cases are when underage people go and drink way too much, get overserved or served at all. They go get in their own car and drive themselves. They get to an accident and they are injured. It's their fault. They're drunk. You can still have a dram shop case against the people that served the minors. Hey, Peter, I am looking for a divorce lawyer for my mother-in-law in Port Charlotte. I am not sure if you give recommendations. Love the show. Keep up the good work. Just Fuzz. Yes, I would love to connect you with somebody. I've got family law lawyers that I know all across the state. Shoot me an email, lawyeryouKnow@gmail.com, and we will hook you up with a couple different referrals. I'll give you a couple different options. Your mom can call them, or your mother-in-law can call them, see who she feels most comfortable with. And do not feel like you have to go with any of them just because I recommended them. At all. I want you guys to make the decision that you feel best about and you're most comfortable with. The client-lawyer relationship is incredibly important, and it's different. Different people like different types of lawyers. Okay, that's all we got, folks. We're right at about the hour mark. Please hit that like button if you guys enjoyed it, if you're still following these cases. More to come on this. I'm hoping to do an Adelson video tomorrow if I can get everything together. It's pretty interesting what's going on, and I think you guys would enjoy that, but we'll see what hits us. Then next week, we've got the Adelson trial starting up. I start trial on Monday. That's why the times have been a little bit weird and different this week. Next week is definitely going to be weird and different. It's not going to be your normal schedule, but please keep coming around. Watch the videos we post, even if they're pre-recorded. Hit that like button as you guys always do. Share it with your friends. But I will be in trial all week next week. I'm looking forward to it. It's been a long time. It feels like, right? We have not gone to, or I have not been in a trial in 2025. So I'm excited to get back in the courtroom here and try this case. I'm supposed to have another one in September as well. So make sure you guys stick around, come hang out. We're going to be talking about stuff. Maybe we'll be able to debrief some stuff that we're doing. And I get to try with my dad, which always excites me. Been a while since I've tried one with him as well. It is a civil case, civil trial. So I'm bringing him along with me instead of the other way around, usually when we do criminal cases. So I appreciate you guys so much. Thanks for being here. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.